Supreme Court of India Raja Khan vs State of Chhattisgarh decided on February 7, 2025 Manu/SC/0157/2025 Facts of the case. The case of the prosecution is that Neeraj Yadav left his house but did not return home. His dead body had been found floating in the pond. It was found that the accused had borrowed money from the deceased and a dispute had arisen between them with respect to refund of the borrowed amount. After the investigation was complete, a charge sheet was filed against the appellant, accused and co-accused Tarachan for committing the offences punishable under Section 302 read with Section 34 and Section 201 of IPC. The trial court acquitted the co-accused Tarachan Varma but convicted the appellant, accused. High Court dismissed the appeal. Findings of the court. The entire case of the prosecution rests on circumstantial evidence, as there is neither any eyewitness nor any judicially admissible confession. It is well settled law that where the case rests entirely on circumstantial evidence, the chain of evidence must be so far complete, such that every hypothesis is excluded but the one proposed to be proved. In such circumstances must show that the act has been done by the appellant, accused within all human probability. To prove the charges, the prosecution has laid emphasis on recovery of weapon of assault, stone as well as the gandasa, and gold chains belonging to the deceased, on the basis of statement, Exhibit P. 23, given by the appellant accused while in custody. Sections 25 and 26 of the Evidence Act stipulate that confession made to a police officer is not admissible. However, Section 27 is an exception to Sections 25 and 26 and serves as a proviso to both these sections. This court is of the view that Section 27 lifts the ban, though partially, to the admissibility of confessions. The question as to whether evidence relating to recovery is sufficient to fasten guilt on the accused was considered by this court in Badraj alias Boda and others versus State of Jammu and Kashmir, 2002, 8 SCC 45. The exact information given by the accused while in custody which led to recovery of the articles has to be proved. Mere statement that the accused led the police and the witnesses to the place where he had concealed the articles is not indicative of the information given. In the present case, the prosecution has produced Tyrith Dhruv, prosecution witness, 22, and Bhuvan Damar, prosecution witness, 26, as the Panch witnesses to prove the recovery pursuant to the disclosure made by the appellant, accused. A bare perusal of the testimonies of the said witnesses raises serious doubts regarding the version of the prosecution with respect to the alleged disclosure made by the appellant, accused herein and the recoveries pursuant to such alleged disclosure. There are also glaring inconsistencies in the tip of the gold chains rendering the proceedings unreliable and inadmissible, as Anwar Hussain, prosecution witness, 20, who identified the two gold chains, has consistently denied that Purnima Yadav, prosecution witness -2, wife of the deceased, identified the two gold chains and that the said gold chains belonged to the deceased. He further denied that 6 more similar chains were placed alongside the said 2 gold chains. This fact has been corroborated by the testimonies of Gopi Sahu, prosecution witness, 6, and Yugal Kishore Varma, prosecution witness, 7, wherein they have stated that only 2 gold chains were placed for identification. Also, as the testimony of prosecution witness, 23 is not corroborated by the testimonies of prosecution witness, 2, prosecution witness, 3 and prosecution witness, 5, this court has doubt with respect to the last seen circumstance. 2. This court is of the opinion that the prosecution has failed to prove the chain of circumstances leading to the guilt of the accused. Beyond reasonable doubt, the conviction of the appellant, accused under Sections 302 and 201 of Indian Penal Code are hereby set aside and the appeal is allowed.